Hi guys, welcome to family law. So we start off with the nature of family law. We will be looking at the concept, requirements of marriage, alternative family relationships, legal rights and obligations of parents and children, and adoption. I haven't got it in front of me, hang on. Yes, I do. So this stuff will take up our first two videos. Okay, so today we will be focusing on, let me double check again. Okay, the first three yellow boxes. So we're going to discuss the difficulty of defining family and the changing concepts of family, distinguish between state and federal jurisdiction in family law, and outline the legal requirements of what is a valid marriage. Alternative family relationships, that comes a little bit under the why it's difficult to define. The concept of family law. The concept of family law includes laws and institutions that govern marriage, alternative family relationships like de facto relationships, legal rights and obligations of parents and children, divorce, including its consequences for children and property, legal ways of dealing with domestic violence, and more recently, same-sex relationships, surrogacy and birth technology. Despite these trends, I don't know if I went to go there first. Let's click again. Oh, here we go. Red box. Discuss the difficulty of defining family and the changing concepts of family. The definition of family is beginning to change in order to reflect changing social trends, which includes alternative family arrangements. Why is it increasingly difficult to define family? Number one, because in 2020, 14.2% of families were headed by a lone parent. 79.3% of these were lone mothers. In 2020, again, 35.6% of all babies were born outside of marriage, ex-nuptial children. Once upon a time, they were called a much more derogatory term than ex-nuptial children. The Australian Bureau of Statistics found in 2020 that there were almost as many families living without children as there were couples with children, so 54.4% without and 45.6% with children. Despite these trends away from the traditional family makeups, the authors of the report argued that families remain the basic unit of society and that most children are raised within a family. Oh, there's a number 4, my God. I'll get there. Also in 2020, of the 6.1 million couple families, 1.4% were same-sex couples. Hence, why it's difficult to define family. Once upon a time, it was a mother, a father, was it 2.5 kids and a dog? Not so much today. Okay, so what comes under federal jurisdiction? Under federal jurisdiction, we have marriage, including same-sex marriage from 2018, divorce, guardianship, custody and maintenance of children, de facto relationship breakdowns since 2008, when most states referred their powers to the federal government, except for Western Australia. Western Australia, much to the beat of their own drum quite often. Thank God you don't live in Western Australia studying legal studies. Under state jurisdiction, historically they have dealt with same-sex couples, that is, relationship registers, alternative family arrangements, adoption, child welfare, which is the care and protection of children, the children's court, surrogacy and IVF, criminal law, for example, domestic law, which we look at in family law, comes under criminal law, and legal aid. Okay, we will, I can't remember why those ones are yellow now, damn. Oh, well, it's going to be a surprise for all of us. Okay, so federal jurisdiction looks at divorce, guardianship, custody and maintenance of children. State looks at child welfare, care and protection of children and the children's court, criminal law and legal aid. I'm going to show you a scenario. I'm 99.9% certain that the whole scenario is in your booklet, and it looks at a case and how all of these agencies can become involved in a single family. So, hypothetical case involving a family. It's deliberately made up, but any family lawyer would see this as a pretty common case that goes before the family courts. So there's a married couple with 3 children under 10. The mother suffers from paranoid schizophrenia and the father is a heroin addict. The mother abuses the children while the father neglects them. A concerned family member calls FACS, who used to be DOCS, but now they're the Department of Justice. We'll get to that later. My God, these agencies keep changing their name. No wonder it's hard to keep track. Okay, so a concerned family member calls the authorities many times and the youngest child is taken away and put into foster care. The couple ends up getting divorced and agrees informally that they will just share responsibility for the 2 remaining children without doing any formal paperwork or going to court. After the divorce, the father finds out mum's gone off meds. Fearing that his remaining children will be taken away, he starts a drug treatment program so he can become the main parent. After a few months, he's doing well, but the mother's getting worse, saying that her medication comes from the government because they want to control her mind. The children say that mum's crazy and they're scared of her. One day, Dad decides that he'll not deliver the kids to her house anymore. He messages the mother, "If you come near our kids again, I will kill you," 100 times. He even sees her on the street one day without the kids, and she yells at him, so he punches her in the face. Again, yes, this is a hypothetical made-up case, but unfortunately, the realities of our world are not always pretty, and this is an ugly example of our world. In our system, this is how it might be dealt with in our system. I'm repeating myself. Where state, federal, courts, agencies, and personnel are involved. So number 1, while they're still married, a New South Wales Family and Community Service FACS. Oh my God, I still haven't changed that. DOJ. We'll get there. Okay. While they're married, the DOJ or a similar family organisation successfully applies to the Children's Court to remove the youngest child from the care of both parents, but leaves the other 2 with them. When the couple's divorce is granted, that is done by the Family Court, which is federal, after a year of separation and a month-long wait for the final divorce. Within Australia, you have to actually be legally separated for a period of time before your divorce can be finalised. The death threat, message and assault case first go to the local court and it's then listed for a trial 6 months later in the district court, both of these under state agencies. Meanwhile, the police apply in the local court for an apprehended domestic violence order to protect the mother from the father, and the magistrate grants a 2-year-old a 2-year apprehended domestic violence order. Okay, I'm sure you're noticing the colour scheme here. So purple, federal, orange, state. Excellent, let's keep going. The father didn't do anything illegal with the kids because he didn't breach any court orders by taking the children away from the mother. So the 2 kids actually stay with him. So the mother applies for an urgent recovery order in the family court to have the 2 children returned to her. The mother also applies for parenting orders in the family court about what will happen with the children in the future. She wants them 100% of the time. The father also wants them 100% of the time. We commonly have referred to this in the past as both parents wanting full custody. Number 6. A lawyer for the 2 children is hired through the Legal Aid Commission of New South Wales to represent the needs of the children in family court. Number 7. The ICL submits to the court that crazy mum isn't worse than possibly imprisoned dad. After a month, a family court judge decides that the children will be returned to live with the mother 100% of the time while they wait for the assault charge to be heard by the district court, because the father could be facing jail. The mother, in return, is ordered to take her medication. 6 months later, the district court finds the father guilty of assaulting. The mother and he both receive a 2-year good behaviour bond. So you can see all the orange and purple there. We've got a lot bouncing between both state and federal courts, agencies and personnel. 12 months after all of this, the family court has an interim hearing to decide what orders for the children will be in place until there's a final hearing. In this 2-hour hearing, nobody gets questioned, and the decision is based only on the documents read by the judge. He reads what the mother has written, what the father has written, the reports written by facts, or the DOJ, about how dangerous the mother is, but no reports for a long time about the father because he is doing much better with his drug addiction. The transcript of the district court decision about the father's assault on the mother. After reading all of this, the family court judge decides that the children will now live 100% of the time with the father because the mother presents no evidence that his heroin addiction interferes with his parenting capabilities anymore. The children were not witness to the assault on the mother. The fact that facts, or the DOJ, has serious concerns about the mother's mental state and refusal to take her medication. The independent children's lawyer believes that the children are safer with the father given that he did not go to jail and he is less likely to try turning them against the mother. So the judge orders that an expert psychiatrist interview the whole family and write a report. Both sides are poor, so they apply for legal aid for that as well. The expert psychiatrist interviews the family, writes a report saying that the mother is best suited to care for the children if she takes her, the word medication is missing there, despite the fact that the children hate her. Remember, they said mum's crazy. 18 months later, a hearing is held for 3 days where everyone is cross-examined. The independent children's lawyer changes his opinion because the father admits under oath that he has started using drugs again. So now the ICL, independent children's lawyer, says the children should live with the mother. During questioning, the writer changes his mind and says that the mother is definitely not going to take her medication, so the children should live with the father. The children aren't questioned at all, and the judge ignores what their wishes are because they're too young to make decisions. The judge takes 3 months to decide the case. The family court judge decides that the children are to live with mum 100% of the time to avoid future conflict and orders the mother to see a psychiatrist and take her meds. That was my phone. My notification is a little fart noise. The father leaves the country and eventually the remaining 2 children end up in foster care as well. Sorry, no happily ever after on that one, but you can see the number of different agencies getting involved with one single family that has a number of issues going on. Family law is important because every family is different, every individual story is different, and looking after the best interests of people in the family is important, particularly when there are kids involved. Okay, so just the family court process in this case, hypothetical case I've shown you, took 3 years. And all of these courts, agencies and personnel were involved. So again, under federal, we had the divorce family court judge, guardianship, custody and maintenance of the children, the family court judge. Under the state jurisdiction, child welfare, the care and protection of children, New South Wales Family and Community Services, now the DOJ, and the children's court judge. Criminal law, because there was domestic violence, meant that New South Wales Police, 2 local court magistrates and a district court judge became involved. And the Legal Aid Commission of New South Wales funded the independent children's lawyer, plus the parents did ask for legal aid help with the case going forward. And the thing is, in this case, nothing really went wrong in the hypothetical case. All the agencies actually worked really well together. I said it wasn't a happy ending, and it's not, but the system upheld its end and did its very best to support this family. Okay, red box, distinguish between state and federal jurisdiction in family law. Again, I don't have the booklet in front of me yet. I won't record video number 2 for this week until after tomorrow when I'm going into school. I'll grab it. Okay. Our system is fragmented, so it is not one whole singular solitary thing taking care of everything. The split between state and federal jurisdictions can be the cause of serious problems. Neither state nor federal courts have the authority to deal with all the legal issues that happen within families. This has been a major problem, especially when it comes to dealing with domestic violence. The Australian Law Reform Commission Family Violence Inquiry of 2010 made recommendations about how to fix the system. Some of the recommendations have been followed by the government, but the system is still fundamentally flawed. New red box. Outline the legal requirements of a valid marriage. The syllabus is, as always, not 100% very clear here because we can look at this a couple of ways. It could mean A. What is required for a marriage to be legal/valid? Or B. What are the legally required actions of people who've entered into a marriage? Legal requirements of a marriage. Both A and B are plausible, so we'll have a bit of a look at both. So the legal definition of a marriage originally came from the case of Hyde versus Hyde back in 1866. It was only written into the Marriage Act 1961 Commonwealth law when the Howard government passed the Marriage Amendment Act 2004 to make sure that the definition purposely did not include same-sex couples. You might recall me talking about this in the past, in the old days when it was face-to-face. It was one of the Scandinavian countries, let's just say Norway or somewhere, introduced same-sex marriage legislation. Little Johnny Howard, who was our Prime Minister at the time, saw that and went, oh no, can't let that happen in Australia. So threw into our Marriage Act the man and woman bit. So the old definition of marriage was the union of a man and a woman, thank you Johnny, to the exclusion of all others voluntarily entered into for life. After the Marriage Amendment Definition and Religious Freedoms Act of 2017, this definition became the union of two people to the exclusion of all others voluntarily entered into for life. No longer a man and a woman. So we don't need to explain the two people part anymore. But there are three other parts of that law that we do need to examine. To the exclusion of all others, voluntarily entered into, and for life. For life. Ugh. Okay, so to the exclusion of all others means that you can't be married to more than one person at the same time. This is actually a crime known as bigamy. But adultery is not in any way against the law. So you can have an affair and you just can't be married to two people at the same time. Drink back. It's only Coke. It's also only about 12:30 in the afternoon. Okay. The second part, voluntarily entered into, means that no person can be forced to marry under duress. For example, if you don't marry me, I'll kill you, sweetheart. Yes, this actually came up in a case in the year I was born, Demento v. Visali. It also means, though, that arranged marriages are not allowed in Australia. This was tested in Crete v. Sampere in 2011. It's actually a crime to coerce, force someone into getting married. This comes under the Crimes Legislation Amendment, Slavery-like Conditions and People Trafficking Act. But it still does happen. Even the mother who killed her daughter, Sanya Sabib, in 2016, was brought to Australia from Fiji as part of an arranged marriage. So that was a criminal murder case, but the thing was the child was brought to Australia to be married off to someone against her will, and that in itself too is against the law. For life. Okay. you are not forced to stay married to somebody if you no longer want to be married to them. So what does it mean when it says it's two people voluntarily entering into, or to the exclusion of all others, voluntarily for life, life. Oh, thank God, it doesn't really apply in Australia anymore because of the Family Law Act, which only allows for divorce on the grounds of an irretrievable breakdown of marriage. That is for the reason of, sorry, I got a bit click happy then. All right, requirements of a valid marriage. So we're moving away from definition. So definition, again, two people to the exclusion of all others, voluntarily entered into for life. Again, not necessarily for life, but there has to be an understanding that it is entered into with the belief that it is going to last for an extended period of time. If you were to get married and after a week end it and then do it again, do it again, do it again, you'd have to start querying whether or not that person was entering into a marriage under the correct terms. Okay, requirements of a valid marriage. If something is valid, it means it's legally recognised. So if a marriage is found to be invalid, the court can nullify the marriage. This annulment means the marriage is deemed to have never legally taken place. However, the children of the marriage would still get the same rights as if the parents were married. You might hear the term annulment bandied around, in particular by people who are really quite religious and their church doesn't allow for divorce. They try to get their marriages annulled, so it's as if the marriage had never taken place, so they can remarry within their church. There are a lot of legal requirements for a marriage to be valid. Pardon me, burp coke. On top of sticking to the definition of marriage. We'll only look at the really interesting ones though, because hey, we have lives. So requirements of a valid real or legal marriage are these. You have to be of marriageable age. No marrying off 12-year-olds, please. There must be parental consent if you are younger than a certain age. Prohibited degrees of relationships, consanguinity. Consanguinity is a term around blood. So, you can't marry your brother or your sister or your dad. I thought there was one more. Okay, marriageable age. What is marriageable age? Under the Marriage Act, 18 years of age. Parental consent permission. Now, what does that mean? People under the age of 16 cannot get married under any circumstances. Nobody over the age of 18 has to ever get parental consent to marry. I'm scared to click the button again in case it doesn't talk about 17-year-olds, but think there is an age between 16 and 18. Aha, thank you. Females at the age of 16, so not under the age of 16, or 17 can apply for a grant of marriage to a magistrate or judge under special circumstances. The technical language is this. Come on, clicker. The circumstances of the case are so exceptional and unusual as to justify the making of the order. So you're 16, 17, and you go, I really love my boyfriend, I want to marry him. Won't necessarily fall under the exceptional and unusual circumstances. Okay, so what are exceptional and unusual circumstances? Have a look at our young couple here. Anyone want to guess their ages? Well, you're about to find out. Okay, pregnancy, getting knocked up, is not an exceptional or unusual circumstance. So that is not a valid reason to get exemption to be married under the age of 18. But in 2008, Lucinda Law was allowed by the local court magistrate in Lismore to permission to get married. She married a 26-year-old man. They both had approval of their parents to marry, though the 26-year-old himself could have been a parent. I'm a bit afeared if I turn the page that doesn't explain why. I'll turn the page, and if it doesn't explain why, I'll just explain anyway. Yep, I think it's not. Okay, so that doesn't want me to go backwards. In the case of Lucinda, they were of a very religious background, and they wanted to be together. The only way they could do that within their religion was for them to legally be married. And I have a funny feeling in the back of my head, maybe, I'm just going to Google it. Give me 2 secs. I'm going to pause here. Pause. Okay, I am reading. She may only be 16, but her parents believe the New South Wales court was carrying out God's will, was religion, when it granted permission for her to marry her 26-year-old boyfriend. Lucinda Law and her beau were given the green light to get married. They began courting when Lucinda was just 14. Oh, he was only 24. Yeah. They met 7 years prior through her father, an elder with a 25-member band of vegetarian independent Christians who call themselves the Manifold Mysteries. This is getting worse. The court made an application to approve the wedding, and it was granted. Both sets of parents went, yay, get married. The judge said he could only grant permission if it was extraordinary or unusual. I'm still looking for this other than maybe it's just scary, weird religion stuff. My computer beeping means that people are emailing me or putting stuff on Google Classroom, but I'm ignoring them. This is our time. They were only the second couple to be granted permission to wed in similar circumstances in 20 years in New South Wales court history. We had no idea it was so rare, said Mr. Ramsey. Blah, 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 blah. Oh, their love blossomed, their church. Something about cooking. Mr. Law said he saw how attached his daughter had become to a man, 10 years older than her. Their love grew stronger. The couple's religious beliefs prohibited them from consummating their relationship. Oh my God. He popped the question when they were watching a documentary about cooking. Somebody fell over backwards, said yes. Oh, she's an amazing cook and makes an excellent vegan lasagna. La 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 la. Yep, no, their exceptional circumstances just seems to be a weird vegan love of God and lasagna. Okay, I'm so sorry. It's been a long time since I looked up that one. Okay, so another requirement of a valid marriage is prohibited degree of relationship. That's when I was talking about bloodlines before. That's Cletus, just like Geordie O'Claw, my favourite. He's married Bernardine, and they probably are cousins. Okay, so this refers to the degree of biological closeness of the people getting married. That is, how closely are they related? Consanguinity, let's see if I got it right before. Yes, means relationship by blood or by a common ancestor. Under Australian law, no one can marry a close family member. Yay, Australia! Not so in some states of America. Under the Marriage Act, a marriage is void, that is not legal, not valid, and never legally exists, where it is between two people who are an ancestor or descendant. So no fathers and daughters and no nanas and grandsons can get married. Brothers and sisters, either related wholly or in part by blood. So can't marry a half brother or sister either, guys. Sorry. These restrictions also apply to adoptive families and relationships. So you can't marry your adopted daughter. Hello, Woody Allen. I suppose Mia Farrow was the one who adopted Suni, but gross. Come on, clicker. Now here comes the kicker. You can legally marry your cousin, your aunt, your uncle, your niece or nephew. Not on the blood-related part though. Ew. But this doesn't mean you should start looking at them differently in next family reunion. So no kissing cousins. What are the legally required actions of people who have entered into a marriage? There are mutual duties of the husband and the wife. Well, that term is a little bit old. I should say there are mutual duties of the two people who are married. Mutual means that these are duties that have to be performed by both people in the marriage. In a marriage, these mutual duties or jobs are called consortium vitae. These are the things that are expected of a married couple. Okay, yes, consortium vitae is a Latin term, not a massive one to remember, but I don't think there's any other, I don't think there's any other big Latin terms. So if this was one you wanted to learn to answer a family law question, have at it, but it's not one of the big Latin terms that I've said, we definitely have to know. Dolly inca pax mens rea, actus rea. Oh my God, what's the other one? You go to court and words. There's evidence that a case can be proven. It'll come back to me later. It's back in criminal law. Okay, so mutual duties include the sharing of household duties, having a sexual relationship. Wait a second. No, it's okay. That doesn't mean that you have a right to sex. That comes under the Crime Sexual Assault Amendment Act of 1981. Prior to 1981, it was very difficult for a person within a marriage to claim that they had been raped because it's seen as a duty of marriage and it wasn't necessarily recognised as a crime under the laws as they stood at the time. It's still working. So that act obviously banned sexual assault in marriage. And also shared duty include responsibility for the care and maintenance of children. So in other words, no, it is not a woman's job purely and solely to look after the children and maintain the family home. These should be shared duties. Okay, this generally doesn't become a problem until someone argues that the marriage is over, they're going for a divorce, or it didn't actually exist and they're going for an annulment. In the case of Campbell v. Cade in 2012, the husband wanted a divorce immediately, saying they'd been separated since 2009 when they started living in separate houses. The wife wanted to, for some reason, argue that they couldn't get a divorce because despite the separate houses, they kept having sex, going to parties together, and operating a joint bank account until late 2011. This was counted as the required consortium vitae, so the judge agreed and refused to grant them a divorce. You might remember earlier I said there has to be a period of 12 months at the very least of legal separation before divorce can be granted in Australia. I was going to add something else about divorce, but I'm 99% positive we'll come to that later. Maintenance. If you're married to someone and you can't support yourself, your husband or wife must financially support you. You cannot be left to live in abject poverty within your relationship. There have actually been cases about this. Elides v. Elides in 81. A judge seriously had to tell a still married couple how to divide their finances in order to fulfill their requirements under family law. In most cases, maintenance only becomes an issue after the couple has separated. Can't remember what's on the next slide, so I'll just chat anyway. So for example, let's say I was working, as I do, and my husband, for whatever reason, was not working, and he was at home and I don't know, looking after the kids, cleaning up after the dogs, whatever. If I kept all the money that I made and didn't give him any money, like maybe I'd give him just enough to cover the bills, and the groceries, but if I didn't give him, money to have some standard of living, then I wouldn't be holding up my end of the maintenance. Okay, so I can't just say, yeah, we're married, I make all the money, I can do whatever I want with it, and you have to wear that same old shirt you've been wearing for 20 years and it's falling apart. You can't do that. Okay, so looking at alternative family relationships. So we've got Aboriginal and Torres Strait Islander people's customary law. Aboriginal and Torres Strait Islander customary law marriages, not just any marriage between Aboriginal people, but actual customary law marriages, do not comply with the requirements of a valid marriage. For example, under customary law, girls younger than 18 may marry, and the marriage itself may not be entirely voluntarily entered into, because sometimes the girls are promised to men before they're old enough to make that decision. So if they're not legal, valid marriages, then what are they? Aboriginal customary law marriages are treated as de facto relationships under the law, which means that they get most of the rights of married couples, including access to the family court if the relationship breaks down. So whilst we might, with our white Western ways, see girls under 18 getting married and not necessarily to people that they want to, if it is customary law, who are we to say what is right and what is wrong? In many cultures, arranged marriages are incredibly successful, and I can't argue against those either. I have personal issues about how young someone is or isn't, but the thing is rather than say to Aboriginal people, you're always wrong, we are allowing them the legal protections by treating those marriages de facto, and they do have pretty much the same rights as married couples, and it's really important they have access to the family court and so forth if the relationship does break down and they are protected under the law. Okay, moving on. Single parent families. Love single parent families. I was, after my father's death, raised in a single parent family, and after the birth of my first son, raised a kid in a single parent family. Back in the days, there was a report that came out of the United States that said children of single parent families were, I'm going to guess the number, I'm going to say 80% more likely to go to jail than children from families with two parents. That's not true. There has been a huge increase in the number of single parent families in Australia. We looked at these figures a little bit earlier. 2020, 14.2% of families were headed by a lone parent. 79.3% of these, it was the mother who was the single parent raising the children. How do families become single parent families? Now, this is actually quite interesting because most people just assume it's because of a relationship breaking down, so that divorce or separation, 66%. As I said, my mother became a single mother after the death of my father, so there are single parent families out there because of becoming widowed. And there are 27% of people who make the decision to raise their children on their own. When I had Zahn, my relationship had broken down, but I live in the modern world where I have choice and control over my body. And I consciously made the decision to go into parenthood as a single person. And that worked for me, and it works for many others. So as I said before, those lovely old statistics from those old reports from the States, we ignore them. My kids aren't in jail. Okay, legal issues when it comes to single parent families. We've got child support. It used to be that an agreement would be made between the residential and non-residential parent. Residential parents, the one that kids live with, non-residential, the ones they don't live with. and they'd have to go to court to force a parent to pay if they weren't contributing. So the legal response here is the child support scheme. The way that child support is calculated is a very interesting one. Not something I would ever recommend getting into discussions, in particular in your HSC. You never know the background of the people that are marking your exam. It could be a deadbeat dad that's marking it, or it could be a woman scorned who's fighting for it. So just know that child support is where the parent who has residential care normally receives money from the parent who does not live with the kids. My brother-in-law just got home next door and is unpacking his truck, so if there's any big bangs and noises, that's Andrew. That's all I can hear now. Okay, legal issue 2, shared parental responsibility. Between 2006 and 2008, changes were made to the family law system, including child support, because of the new emphasis of shared parenting. Some men are paying less, and more women than ever are having to pay child support payments. The reason for this disparity can be based on the percentage of time that each parent shares with the child, or it can come down to who's earning what, and the parent who's on a lesser income receiving financial support from the parent with a better income, despite the fact they might have the children less. But things are supposed to be in the best interest of the child, and so by allowing the parent with less resources to have access to more resources, one is banking on that rolling over to the kids being looked after better. Again, kind of contentious, wouldn't get into it too much if you can avoid it, not knowing who is marking your exam and what their personal experiences are. Blended families. I love a blended family. The family court can order a step parent to pay financial support if it can be shown that the step parent has a duty to maintain the child. This comes under the Family Law Act. The process for a step parent to adopt their partner's child is much easier than a regular adoption. That is a great thing. Stepchildren do not have an automatic claim to the estate of their step parent if the step parent dies without a will. They will have to prove that they were financially dependent on the step parent. That comes under the Succession Act. So I'm pretty confident the next slide is a little bit more about blended families, otherwise I'll talk about it. Let's see. Aha, there it is, the Brady Bunch. I'm really old, or you're way too young if you don't know the Brady Bunch. The Brady Bunch was a sitcom where Carol, the nice blonde lady at the top there, who had 3 daughters, Marsha, Jan and Cindy, met and married Mike Brady. Mike is what was supposed to be considered the handsome gentleman in the middle at the bottom. And Mike had 3 sons, Greg, Peter and Bobby. And these 2 families came together and is a blended family. So children from different relationships, all becoming brother and sister. And if you're wondering about the lady in the middle, that's Alice, the housekeeper. 1/3 of all registered marriages involve individuals who are marrying for the second time. Blended families are families where a couple lives together, either married or de facto, with children from previous relationships. However, these couples may also produce more children who are fully related to both parents. Blended, different, like a cocktail. De facto relationships. These are relationships where 2 people, hetero or homosexual, live together on a permanent basis and also share a sexual relationship. The legal phrase is that they need to live together on a genuine domestic basis. Basically, it's people living, oh, not me, swear to God, brother-in-law. Basically, it's people living as a married couple without legally being married. What is he doing? I'm going to look out the window, pardon. Oh, wheelie bins. It's been night. Okay, but yeah, that sounded uncomfortable. De facto relationships, got a few cases we can look at here. In Rishi v. Jones, it was found that it is up to the person bringing the case to court to prove that there was a de facto relationship. In Jonah v. White, the guy was married during the 13-year relationship. They never lived together though, so just adding up the time doesn't count. In Sinclair v. Whitaker, the relationship went for about 6 years, but the guy didn't admit it. The judge says it doesn't matter whether the person thinks there's a de facto relationship, so that's too bad. So essentially, Sinclair v. Whitaker, they were living together and operating as a married couple does with shared domestic responsibilities. It's just when it was time to break up, he goes, oh, it wasn't in a de facto relationship. And the judge went, whether or not you want to use that label, you were acting as though you were married as such and having that domestic relationship, so that is how you'll be treated under the law. Oh, here's the top tricky thing. So yes, but you can actually be in multiple de facto relationships, and you can actually be married and also in a de facto relationship. The rights people have when they separate are basically like married couples. So court cases in this area are usually a fight over whether there was a de facto relationship, and that's where those important cases come in. I don't know why I scheduled it to pop up first. Making sense? Okay. De facto, break up, go to family court, as you would with a divorce, divvy up assets, work out what's happening with the kids, same rules as married people, proving whether or not you were in a de facto relationship. Okay, so first case, person taken to court has proved that there was a de facto relationship. Just because you're with someone over an extended period of time doesn't make it a de facto relationship unless you're actually living together with that domestic household agreement, like living like an actual married person. And just because you don't want to say it's a de facto relationship doesn't mean you're not exempt from the normal laws governing divorce. De facto couples can now access the family court. This came about in 2008 when there was an amendment made to family law for the de facto financial matters and other measures. So what this means is when a de facto couple separates, including same-sex de facto couples, the entire separation is resolved through the federal system, dispute resolution, parenting orders, etc. This is better for de facto couples and any children they've had together because they don't have to go through two separate courts. They can have it all done under the federal system. Same-sex relationships. Okay, so same-sex couples historically have not had equal rights under Australian family law. Historically. Bad. Took a long time. We see this in the Same Entitlements Australian Human Rights Commission that happened back in 2007. The government response, the federal government amended 84 Commonwealth Acts through the Same-Sex Relationship Equal Treatment in Commonwealth Law's General Law Reform Act in 2008 after this Human Rights Commission happened. So this actually removed discriminatory treatment of same-sex couples. So the Marriage Act had still not been amended to allow for same-sex marriage at that time, again, historically. The Greens and a Labor MP did try to get the Marriage Amendment Bill through in 2012, through Parliament that is, but they failed. They were trying to have same-sex marriage allowed. Can't remember if we get right into this now or if we leave it for our contemporary issue, but you know that changes happen. But historically, it took a long time. In 2017, the same-sex marriage plebiscite was held. The Commonwealth government spent about, I love it, $122 million on a survey about gay marriage. 62% of Australians voted yes, which was in line with other surveys that had been done. So it was pretty predictable. But this had zero legal effect because it was a plebiscite, not a referendum. So a plebiscite is a grand survey that costs a lot of money. A referendum is similar in that it's a vote that people do at home and post in, but if it's a referendum, it is legally binding. So, for example, a referendum was held to give Aboriginal people rights in Australia. So people voted yay or nay, similar to they voted in the plebiscite, yes or no. But because it was a referendum, it automatically became law when the referendum had a higher percentage of people voting yes than no. So that's the difference with the plebiscite and the referendum. And I think it's an important thing to note that, you know, the government did spend so much money on a survey that essentially it meant nothing, and also agreed with every other non-$122 million survey that they've done in communities prior to 2017. Okay, but off my rant. But because of this, the Marriage Amendment Definitions and Religious Freedoms Act of 2017 was passed. Some members of Parliament still voted however they wanted to, rather than whether their electorate told them to, which means they're not doing their job. Politicians, in their mind, their job is to be popular, but the politician's job is to represent the people that vote for them. Okay, and lastly, polygamous relationships. So these are alternative family relationships. Polygamy is having more than one wife or husband. While some cultures and religions allow polygamous marriages overseas, polygamous marriages are not legal in Australia. However, a polygamous marriage that was entered into overseas can be deemed to be, or that is seen as, a marriage if there's an issue that goes to court. This is good because it protects people that are already within these relationships, and family law should be about protecting the people in the family unit. A marriage will be declared invalid if one of the parties was already married. This was shown in Mathis v. Hughes 2011. Marrying a second person when you're already married is also a crime known as bigamy. So that comes under the Crimes Act. Bigamist admits 14 divorce papers, ABC News 2010. Okay guys, that is the end of video number 1. It's taken me, according to this, 52 minutes and 43 seconds. I hope that wasn't too long. Yeah, and I will record another one tomorrow. So have a great day, guys. Miss you all. Bye.